There's been a settlement of the Swift Transportation Owner-Operator Misclassification lawsuit that has been going on for nearly 10 years. And this video is here to give you some answers to questions you may have about what the settlement is and how it will work.
If you're covered by the settlement, you should have received a notice from the settlement administrator, Settlement Services Incorporated, or SSI. Please read this notice carefully.
SSI will be administering the settlement through this notice phase. Their phone number is, and I'm going to check here, 844-330-6991. SSI will always be able to give you much more information, so remember that number.
If you have any questions that aren't answered in the notice or in this video, then please call SSI, the settlement administrator, or you can go to the settlement website, swiftmisclass.com.
You may be asking, why did I get a notice? You got a notice if you are a class member in the settlement. The settlement is tentative, it's not final, and the notice explains your rights. To be a member of the class, you have to meet two criteria. One, you leased a truck from Interstate Equipment Leasing, and two, you drove for Swift between the specified time period, which is from December 1999 through January 1, 2019.
So you must have signed a lease with IEL and an owner-operator contract with Swift. The notice lays out all your options and the deadlines to exercise these options, so please read your notice carefully and promptly to ensure that you don't miss any of these important deadlines.
Some people may be asking, why didn't I get a notice? There are a couple of reasons. One is, we may not have your correct address, you may have moved, the mail might have gotten lost, somebody at your home discarded the notice, or it got lost, or any number of reasons like that. You may not have been home for a long while. But it's also possible that you didn't get a notice because you're not properly part of the case. And again, the two criteria for being class members are having a lease, that meaning you signed a lease with Interstate Equipment Leasing, and you signed an independent contractor operating agreement to drive for Swift.
So some of the reasons that you might not be part of the settlement is that you didn't have a lease with IEL and an operating agreement with Swift during the relevant time period, that is December 22nd, 1999 through January 1st of 2019. You might have also worked for Swift as an owner-operator but leased your truck from an entity other than IEL. So for example, Central Leasing, Wasatch Leasing, or another leasing company. Or you may have owned your truck. It's possible that you were a team driver and so you didn't sign a lease with IEL or an owner-operator agreement with Swift. You could have also leased a truck from IEL but not driven directly for Swift Transportation.
It's also possible that a mistake was made. So, if you think you meet the criteria for being part of the case and you did not receive a notice, you can call the claims administrator to find out if you should have gotten a notice or if you are in fact on the class list. So again, that number is 844-330-6991 to speak to SSI, the claims administrator in this case. Each driver in the settlement class has a settlement share allocated to them out of the $100 million settlement. That share is calculated the same way for everyone, but it may apply to each person different based on the factors of their driving experience. Those different factors that may cause some people's numbers to go up or down include the length of time they drove for Swift, the number of miles they drove, the amount of pay they received while they were driving, the amount of deductions they had, the amount of out-of-pocket deductions they're presumed to have, whether they filed a consent to sue to join the case early within the time period that the case has been going on, and the time period that they drove. Each of those factors affect the ultimate settlement amount that is allocated to each driver, and that allocation formula is described in fuller detail within the settlement notice. Is this settlement fair? Getman Sweeney Dunn believes that this settlement is in the best interests of the drivers who are participants in the case. And so, yes, we heartily recommend the settlement. The reason we do is this: claims are uncertain. This case has been very hard fought for 10 years. And we are nowhere close to reaching a resolution of the claims without a settlement. This case could go on for a great many more years. We've been to the Circuit Court of Appeals, the Ninth Circuit, many times in this case already, and there are many more issues that would have to be decided and likely many more trips to the circuit. There are uncertain claims in this case as in every case. It is hard to predict whether drivers will win this claim or that claim or no claims. So it is possible that all claims could be lost if we were to go forward and not settle. It's possible that we would win only small claims, or that a court would refuse to certify a class and refuse to allow all the class members, such as yourselves, to participate in the settlement. Taking into account the various risks that I just discussed, the attorneys on this case strongly believe that the dollar value of the settlement represents fair compensation to drivers for the risks that they will win or not win all the different aspects of the case.
And for those drivers who don't think that the settlement is fair for them individually, you do have the option of opting out of the settlement. So again, please read your notice carefully. It's going to lay out all the options that you have, all your rights in the settlement, and how to exercise those options, and also the deadlines for those options. It's also important to note that the court supervises the settlement, and in the end, the court will make a decision about whether the settlement is fair for all the drivers. The court will hold a hearing to consider whether the settlement is fair, reasonable, and adequate for all of the drivers. The court will also address any timely objections that have been filed with the court. The court will hold a final fairness hearing on January 22nd, 2020 in the federal courthouse in Phoenix, Arizona.
We estimate that the entire process from sending out notice to the drivers getting paid if the settlement is approved will take approximately 6 months. During the course of that time, it may be that you will move or that you already have moved. It's vitally important that you stay in touch with the settlement administrator, SSI, at the number that we will leave again on this video. That's where you should send your updated contact information. That's critically important.